Usually when we talk about a medical diagnosis, there's this comforting expectation of precision.
Yeah.
It's kind of like engineering.
Oh, absolutely. Like, you break your arm, you go to the hospital, and the x-ray just shows that jagged white line on the dark film.
Right, exactly. The doctor just points to it. It's broken or it's not broken. The whole mechanism of cause and effect is just, entirely visible.
Yeah, and we really crave that visibility. I mean, we want the world to be cleanly categorized into cause and effect because it makes tragedy feel manageable, right? Like,
Right.
if we can see the broken bone, we can fix it.
But the moment you step out of the hospital and, into the world of civil liability, specifically this sprawling universe of tort law and negligence, that metaphorical x-ray machine just shatters.
Oh, completely
Yeah.
shatters into a million pieces.
Right. We are no longer looking at a clear, jagged line. We're looking at a diagnostic landscape that is incredibly murky, built entirely out of the complex, unpredictable web of human behavior.
Because in tort law, we aren't just asking what happened. We're asking who pays for the fact that a life was ruined.
And today, for this deep dive, we're glad you're here with us because we're going to figure out exactly how society makes that terrifying calculation. We've got a massive stack of source materials powering this deep dive today, too.
Yeah, we're pulling from foundational tort law notes, specific case briefs, appellate court rulings, and this really highly conceptual infographic titled Negligence, Inc.
Right, so let's get right into it. That calculation you mentioned, it's really the beating heart of civil justice.
It is. I mean, when a devastating injury occurs, the initial human instinct is to just find someone to blame, right? And force them to make the victim whole.
Sure, that's human nature.
But if society simply compensated everyone who got hurt, well, the entire economic system would just collapse overnight.
Right, insurance premiums would be astronomical, businesses would shutter.
Exactly. Human progress would grind to a total halt. So the legal system had to invent a filter, a highly rigid, sometimes really ruthless filter designed to justify exactly when an injury is someone else's legal fault.
And we're going to explore that filter today. So I want you to imagine this system as a massive, bureaucratic corporate structure. Let's call it Negligence Incorporated.
I like that analogy.
Thanks. So if you are injured and you want to successfully sue someone, you are the plaintiff. Your job is to take your project, which is your lawsuit, and get it approved by the board of directors at this corporation.
Right. In legal terms, you're trying to build a prima facie case.
Prima facie, which is Latin, right?
Yeah, it's Latin for at first sight or on its face. It basically means you've presented the minimum amount of required evidence to prove your claim, assuming the other side doesn't refute it.
Okay, so to build that prima facie case in Negligence, Inc., you have to secure a stamp of approval from 4 distinct, highly scrutinized departments.
And each of these departments is run by a completely unforgiving senior vice president.
Very unforgiving. So first you have the SVP of duty, then the SVP of breach.
Right.
After that, you've got the SVP of causation, which is actually kind of a 2-part gauntlet, right? Actual cause and proximate cause.
Yeah, it's a massive hurdle. And finally, the SVP of damages.
So what happens if you get approval from duty, breach, and causation, but the SVP of damages finds a flaw in your file?
The entire lawsuit is dismissed, just thrown out. There is no partial credit in Negligence, Inc. You walk away with absolutely nothing.
Wow. So negligence is really like a massive chain of dominoes. Duty and breach set up the dominoes, but causation is proving that the defendant's specific flick of the finger is what knocked them down.
Exactly.
And damage is proving that the dominoes actually broke when they fell. If any single part of that sequence is missing, the chain stops.
But wait, is it really that black and white? Like, if someone is objectively, horrifically injured through no fault of their own, can a technicality in just one of these legal departments actually throw the whole case in the trash?
Honestly,
Yeah.
it happens every single day in courtrooms across the world. That's rough.
It is, but it happens because the law prioritizes systemic stability over individual tragedy. The 4 departments aren't there to hand out lottery tickets to the injured.
Right.
They exist to shift the financial burden of an injury from the victim to the wrongdoer, but only when the wrongdoer's conduct falls below the strict standards society has agreed upon.
Okay, so let's start exploring those standards. We need to look at the very foundation of this entire system, which means dealing with the SVP of duty.
The threshold question.
Right, because before a jury can even look at whether someone acted recklessly, they have to answer this fundamental philosophical question. Did this person have a legal obligation to act correctly toward the injured person in the first place?
Yeah, and the law doesn't demand that you are perfectly safe at all times toward all people. That would be impossible.
So what does it demand?
Generally speaking, the law mandates that we owe a duty to avoid causing foreseeable personal injury to foreseeable plaintiffs.
Foreseeable plaintiffs.
Okay. Right, and we measure this obligation using an objective baseline known as the reasonable prudent person standard.
The RPP, the fictional perfectly average human being that the law uses as a measuring stick.
Exactly. This fictional person is basically the most important ghost in the legal system.
Ghost in the machine, yeah.
Because the RPP standard is entirely objective. If you cause a car crash, the jury doesn't care if you're naturally a clumsy person.
Or if you were having a terrible day.
Right. Or if you genuinely tried your absolute best to avoid the accident. Subjective good intentions are completely irrelevant.
Wow. So trying your best doesn't matter.
Not at all. The jury asks one question. What would a reasonably prudent person have done under those exact same circumstances? If a reasonable person would have braked earlier and you didn't, you failed the standard.
Okay, that seems fair in theory, but it gets incredibly complicated when we try to figure out who we actually owe this reasonable behavior to, right?
Yeah.
Like, are we legally responsible for everyone on Earth?
Well, that exact question created one of the most famous philosophical splits in legal history. It was driven by two towering judicial figures, Judge Benjamin Cardozo and Judge William Andrews.
Oh, right. They looked at the exact same concept of duty and came to entirely different conclusions about the boundaries of human responsibility. Let's break down that split for everyone listening. What is the Cardozo view?
So Cardozo championed the idea of the zone of danger.
The zone of danger. Sounds like a movie.
It does, right. Under his view, which, by the way, is the majority rule in most jurisdictions today, you only owe a duty of care to foreseeable plaintiffs who are located within a specific geographical or relational zone of risk created by your actions.
Okay, give me an example of that.
Imagine you're driving a car and you carelessly run a red light and you smash into another vehicle in the intersection. The driver of that other car is clearly a foreseeable plaintiff in the zone of danger. You owed them a duty.
Okay, but what if, say, a mile down the road, someone is drinking a hot coffee on their balcony? They hear the screeching tires and the massive crash from your accident. They get startled. They drop the boiling coffee on their lap and suffer severe burns. Did I owe a duty to the person on the balcony a mile away?
Under Cardozo? Absolutely not. That person on the balcony was entirely unforeseeable and located way outside the zone of danger.
Right.
Therefore, regarding the coffee burn, you committed no tort. You owed them no duty, which means the SVP of duty rejects their lawsuit before it even begins.
Boom. Case over.
Exactly.
And the Andrews view looks at this differently.
Yeah, Andrews argued for the minority approach, which basically states that duty is owed to the world at large.
The world at large. That's broad.
Very broad. His philosophy was that if you choose to act negligently, and that negligence creates a ripple effect that somehow ends up hurting someone anywhere, you owe them a duty, period.
Wow.
Yeah. Andrews believed that drawing an arbitrary zone was just an artificial way for society to wash its hands of the true consequences of reckless behavior.
It's a profound difference in how we view societal connection, honestly.
Mhm.
But, even if we stick with the standard reasonable, prudent person, the law has to make exceptions, right? Because a perfectly objective standard doesn't make sense for everyone. Like, what happens when the defendant is a child?
Right, you can't expect a 7-year-old to have the situational awareness of a 30-year-old.
Exactly. So how does Negligence, Inc. handle that?
The law recognizes the reality of cognitive development. So for children, the SVP of duty actually modifies the standard. A child is generally held to the standard of a reasonably prudent child of similar age, intelligence, and experience.
Okay, so it's a more subjective, tailored approach. We evaluate the 7-year-old against what other 7-year-olds would do.
Precisely.
But there is a massive trapdoor in that rule, isn't there?
Yeah.
If a child is engaging in what the law calls an adult activity, they lose that protective childhood shield entirely.
They absolutely do. The classic example is operating motorized vehicles. Yeah, if a 14-year-old decides to take a high-powered snowmobile out for a joyride and crashes into a skier, the skier's lawyer isn't going to let the jury judge the defendant as just a naive teenager.
Right, because the law dictates that driving a heavy motorized vehicle is an inherently dangerous adult activity.
Exactly. If you choose to engage in it, society demands that you be held to the strict, unforgiving, adult, reasonable, prudent person standard.
That makes perfect sense. I mean, the machine doesn't care how old the driver is when it causes damage.
Yeah.
Now, what about adults with disabilities? because the legal system draws a very sharp, very deliberate line between physical and mental impairments.
It does, and this is an area where legal policy often clashes with modern empathy.
How so?
Well, for physical impairments, the standard is modified to accommodate reality. If a person is blind, we don't judge their actions against a sighted person. We judge them against what a reasonably prudent blind person would do under similar circumstances. The physical limitation is baked right into the standard.
Okay, but if someone suffers from a severe mental disability, the rule flips.
It does.
Adults with mental disabilities are held to the exact same objective standard as a reasonable person without any mental capacity issues. I imagine a lot of people listening find that incredibly harsh. Why does the law ignore mental reality?
It stems from historical anxieties, mostly, and practical public policy. Centuries ago, courts were deeply paranoid that defendants would simply fake mental illnesses or cognitive deficits to escape financial liability for the damage they caused.
Ah, I see.
Yeah, physical disabilities were visible and verifiable, right? But mental disabilities were viewed with a lot of suspicion.
It makes sense historically, even if it feels harsh now.
Plus, the courts wanted to incentivize the families and caretakers of mentally disabled individuals to maintain strict supervision over them. The logic was, if the disabled individual could easily be sued, the family would be more likely to keep them from causing harm to the public.
Interesting. There is a really fascinating exception to this, though. The employed caregiver exception. Let's say a family hires a professional nurse to care for an adult with severe dementia, and part of the dementia manifests as, sudden physical aggression.
Right.
If a patient has an episode and injures the nurse, can the nurse sue the patient for negligence?
In most cases involving an employed caregiver, no. The law determines that the disabled person owes no duty of care to the professional in that highly specific scenario.
Because of assumption of risk.
Exactly. The caregiver was specifically hired and compensated to manage the exact risks associated with that person's disability. You just cannot sue someone for manifesting the very symptoms you were employed to handle.
Right. Speaking of professionals, how does the SVP of duty handle highly specialized fields? If a surgeon leaves a sponge inside a patient or an architect designs a bridge that collapses, we clearly can't ask what the average person on the street would have done.
No, definitely not. Professional negligence, which is commonly known as malpractice, elevates the standard of care. Doctors, lawyers, engineers, accountants, they're judged against the standard of a minimally competent professional in their specific field, exercising reasonable diligence and skill.
So we aren't comparing the surgeon to an average person. We're comparing them to other trained surgeons.
Exactly.
But to even trigger that professional standard, there has to be a formalized relationship first, right? Like you can't just walk up to a cardiologist at a cocktail party, ask for casual advice about chest pain, and then sue for medical malpractice when you have a heart attack the next day.
No, you can't. The professional duty of care remains totally locked until the formal relationship, like the doctor-patient relationship, is established. That relationship is the bridge that legally connects the professional's expertise to the patient's reliance.
Okay, this brings us to a part of the law that honestly genuinely enrages people when they first learn about it.
I know exactly what you're going to say.
Yeah, we need to talk about the difference between misfeasance and nonfeasance and how it leads to the no duty to rescue rule.
Right. So misfeasance is active misconduct. It's when you do something affirmatively dangerous that puts another person in a worse position.
Like running a red light, leaving a loaded gun on a table, building a faulty staircase.
Exactly. The law has absolutely no problem imposing a duty of care on active misfeasance. But nonfeasance, however, is a passive failure to act. It's simply doing nothing.
Okay, let me set up a scenario for you, and you tell me how the law handles it.
Go for it.
I am walking by a shallow pond. I am a perfectly capable swimmer. I see a stranger in the water, and they are actively visibly drowning. There is a bright orange life preserver sitting on the grass right next to my foot.
Okay.
It would require zero effort and zero risk for me to just kick that life preserver into the water and save their life. Do I have a legal obligation to do it?
Under the strict Anglo-American common law rule, you have absolutely no legal duty to assist that stranger.
Wait, really?
Truly. You can sit down on the grass, watch them drown, and perhaps even pull out a sandwich and eat it while they slip under the water.
That sounds completely monstrous. Like, I'm honestly furious just hearing it described that way. How can a civilized society build a legal system that permits that kind of callousness.
I know it shocks the conscience, but the legal rationale is actually deeply embedded in the concept of individual liberty. The common law draws an impenetrable wall between causing a harm and failing to prevent a harm.
Right.
The legal system was designed to punish people who make the world more dangerous. If you are just a bystander, you didn't create the peril. The drowning person was going to drown whether you were walking by or not.
So,
The law is profoundly reluctant to force free citizens to become involuntary rescuers because once you mandate rescue, where do you draw the line? Must you give all your disposable income to starving children? Must you donate a kidney to a stranger? The law protects your negative liberty, the right to be left alone.
I hear the philosophy, but there have to be exceptions.
Yeah.
The law can't just let everyone watch everyone else die.
No, it's not entirely heartless. The law has carved out specific scenarios where an affirmative duty to rescue does arise.
Okay, what's the first exception?
The most prominent one is if you, the defendant, caused the peril in the first place, even if you did it completely innocently.
So if I accidentally trip on a root, bump into a stranger, and knock them into that pond, I can't just walk away anymore.
Exactly. Because your physical action created the dangerous situation, the law immediately attaches a duty. You must now take reasonable steps to rescue them.
Makes sense. What else?
The second major exception involves a special relationship. The law dictates that certain relational bonds come with an inherent duty of protection.
Like what kind of bonds?
Common carriers like airlines and buses owe a duty to their passengers. Innkeepers owe a duty to their guests. Employers must aid employees injured on the job.
Right.
If a customer collapses from a heart attack in the middle of a grocery store, the store owner cannot simply step over the body. They have an affirmative duty to take reasonable steps to assist.
Which usually just means calling 911, right?
Yeah, exactly. Just calling for emergency medical help.
Let's look at a case that pushes these rescue exceptions to their absolute breaking point. It's a case called Podias v. Mayers. Paint the picture for us.
It's a really tragic, intense scenario. We have a driver, Mayers, who is out late at night with several friends in his car. They're driving down a dark road, and Mayers strikes a pedestrian named Podias, who was riding a motorcycle.
Okay.
Podias is thrown onto the pavement and is lying completely helpless in the middle of the dark road.
The driver, Mayers, is clearly liable for hitting him. That's active misfeasance. But the lawsuit takes a different angle, doesn't it? It focuses on the passengers in the car.
Right. The passengers didn't touch the steering wheel. They didn't hit the pedestrian. Under the strict nonfeasance rule, they're just bystanders. They argued they had no legal duty to do anything.
But the facts get worse.
So much worse. The passengers get out, they see Podias bleeding in the road, they realize their driver is panicked and potentially intoxicated, and they know the driver is unwilling to call the police. Instead of calling 911 themselves, which they easily could have done with their cell phones, they all get back in the car, abandon the helpless victim in the middle of the road, and drive away.
Oh, wow.
Yeah. And shortly after, another car comes along and fatally strikes Podias.
The victim's family sues the passengers. Under the strict rule, they should lose, right? Because the passengers didn't create the peril.
That was the passenger's exact defense. But the court had to grapple with the horrific reality of the situation. The court ruled that being involved in the incident, being inside the specific vehicle that caused the massive trauma, well, it created an ad hoc relational nexus.
An ad hoc relational nexus, basically a temporary special relationship.
Exactly. It formed a temporary bond that pulled the passengers out of the category of innocent, disconnected strangers on the street. They were uniquely positioned to know about the extreme peril, they knew the driver wasn't going to help, and calling 911 represented a microscopic burden.
Right.
So the court found that under these highly specific circumstances, a duty to act could exist.
It's a powerful example of the law trying to stretch its own rigid rules to achieve a moral outcome. But we have another case, Gano, that explores the strict temporal boundaries of a rescue attempt. Because if you do decide to voluntarily help someone, you assume a duty to do it reasonably.
Voluntary assumption of duty is a well-known concept. If you decide to throw the life preserver, you can't yank it away at the last second as a joke.
No, that would be terrible.
Right. Once you start a rescue, you must act reasonably. But Gano asks what actually counts as a rescue.
Right. In Gano, a customer goes to a hardware store and buys some heavy materials. A store employee helps the customer load the heavy materials into the back of the customer's truck. The customer drives away, the load shifts, causes an accident, and the customer is injured.
Right.
So the customer tries to sue the store, basically arguing, hey, your employee started to help me, which was a voluntary rescue, so you assumed a legal duty to make sure I was perfectly safe.
And the court firmly rejected that argument. Gano establishes that ordinary preliminary commercial assistance just cannot be retroactively classified as a legal rescue attempt that binds the defendant to a perpetual duty.
Right. Helping someone load a truck is just a basic courtesy of commerce.
Right.
It doesn't mean the employee has legally guaranteed the safety of the driver's entire journey home.
Precisely.
So if you're the plaintiff and you manage to navigate all of this, you prove you were a foreseeable plaintiff, you prove the standard of care, and you prove a duty existed, the SVP of duty finally stamps your file. You survived the first department.
But you're not done.
Far from it. Now, you walk your lawsuit over to the SVP of breach.
Establishing a duty just gets you in the building. Now you have to prove the defendant actually failed to meet that standard. You have to prove their conduct fell below the line of reasonable care.
And this is where we have to define what unreasonable actually means in a courtroom. It's one thing to say someone acted carelessly, it's another to prove it objectively. To do this, courts rely on an algebraic equation created by the legendary Judge Learned Hand. It's literally known as the Hand formula.
The famous Hand formula. Its B is less than PL.
Wait, break that math down for us.
It states that a breach of duty occurs if the burden, which is B, of taking precautions to avoid the harm, is less than the probability, the P, of the harm occurring multiplied by the severity of the loss, the L.
Okay, when I first encountered this, I was, genuinely repulsed. We are taking human life, human suffering, severed limbs, and traumatic brain injuries, and we're plugging them into a cold algebraic equation to decide if someone gets paid. We are putting a dollar value on safety.
I know it sounds incredibly clinical and perhaps a bit dystopian, but honestly, I will defend the Hand formula as the most vital mechanism in civil society. It is the math that allows human progress to exist.
Really? How so?
Think about it. If the law demanded 100% perfect safety from every conceivable risk, modern life would end. If we wanted to guarantee that no one ever died in a car crash again, we could simply mandate a national speed limit of 4 miles per hour.
True. The probability of death would drop to zero.
Exactly. But the burden on society, the destruction of supply chains, the inability of ambulances to reach hospitals, the collapse of the economy would be astronomical.
So the Hand formula isn't demanding perfect safety. It's trying to measure when a risk becomes unreasonable compared to its social utility.
Exactly. Let's say a factory has a machine with an exposed gear. Every year, there is a 10% probability, the P, that a worker will catch their sleeve in the gear, resulting in a severed arm, a massive loss, the L.
Okay.
If the factory owner could install a simple plastic guard over the gear for $5, a tiny burden, the B, then the owner is in breach of their duty. It was simply too cheap and too easy to prevent a catastrophic harm. But if preventing that gear from catching a sleeve required shutting down the factory, completely redesigning the machinery for $10 million, and halting the production of vital medical supplies, well, the burden might outweigh the risk.
It's a brutal risk calculus. But taking that algebra into a courtroom and trying to prove every variable to a jury of laypeople sounds exhausting. And incredibly expensive.
Oh, it is. Thankfully, the SVP of breach provides a couple of evidentiary shortcuts for plaintiffs.
Let's talk about those shortcuts. They seem crucial when direct evidence of the breach is either missing or locked away.
They really are. The first shortcut is a doctrine rooted in a Latin phrase, res ipsa loquitur.
The thing speaks for itself.
Yes.
I find the history of this fascinating. This rule was developed during the 19th century Industrial Revolution, right?
Yeah.
A time when massive new technologies like steam trains and mechanized factories were causing horrible accidents.
Yeah, but the victims had absolutely no way to access the corporate records or figure out exactly what the engineers did wrong.
Right, the courts realized that if a plaintiff had to mathematically prove the exact mechanical failure that caused a train to derail, the corporations would win every single time.
Exactly. So they created res ipsa loquitur to level the playing field. The foundational case for this is Byrne v. Bodle from 1863 in Liverpool, England.
It's such a beautifully simple scenario. A man named Byrne is just walking down the sidewalk, minding his own business, passing by a multi-story warehouse owned by a flour dealer named Bodle.
And suddenly, a massive, heavy barrel of flour plummets out of a second-story window and crushes Byrne on the street below.
Ouch. Byrne suffers severe injuries. He sues the warehouse owner. But here's his problem. Byrne was outside.
Right.
He has no idea who pushed the barrel. He doesn't know if a rope snapped. He doesn't know if an employee was drunk. He just knows a barrel fell on his head.
Under normal rules of negligence, his case would be thrown out because he can't pinpoint the exact breach of duty. He can't run the hand formula on a barrel he didn't see fall.
But the court looked at this and basically said, come on, barrels don't just leap out of windows on their own.
The court allowed the jury to infer negligence without direct proof, creating a three-part test for res ipsa loquitur. First, the plaintiff must prove that this specific type of accident doesn't normally happen in the absence of someone's negligence. As you said, barrels don't defy gravity without human error.
Right. And the second part?
Second, the plaintiff must prove that the instrumentality causing the harm, the warehouse and the barrel, were under the exclusive control of the defendant.
And third?
Third, the plaintiff must prove that they did not contribute to the accident in any way.
Well, Byrne was just walking by. He didn't magically summon the barrel. So because he met all three criteria, the thing speaks for itself. The burden shifts to the warehouse owner to somehow prove they weren't negligent, which is incredibly difficult.
It really is. Now, the other major shortcut through the SVP of breach is called negligence per se. This occurs when a legislative body has already done the math of the hand formula for society and codified it into a specific statute or law.
So instead of arguing about what a reasonable person would do, you just point to a law on the books.
Yeah. Let's say a local city council passes a law stating that all residential swimming pools must be surrounded by a fence at least 5 feet tall. The legislature has basically already decided that the burden of building a fence is universally less than the risk of a child drowning.
Right.
If a homeowner decides not to build the fence and a neighborhood toddler wanders into the yard and tragically drowns, the victim's family doesn't have to convince a jury that the homeowner was generally unreasonable. They simply prove the homeowner violated the statute.
But there are strict guardrails on negligence per se, right? You can't just use any broken law to prove negligence.
Definitely not. The legal rule states that the statute must be intended to protect a specific class of people from a specific type of harm.
Okay, so in the pool example, the statute was clearly designed to protect young children, that's the class of people, from accidental drowning, which is the specific harm.
Because the actual event perfectly matches the legislative intent, the breach is automatic.
But what if the homeowner didn't build the fence, and during a storm, a massive tree branch crushes a passing car? The driver sues, saying, hey, you didn't have a pool fence, which breaks the law, so you are negligent per se for my crushed car.
The judge would laugh them out of court. A pool fence statute is not designed to protect passing motorists from falling tree branches. The class of people and the type of harm just don't match, so negligence per se cannot be used.
Now, even if the harm matches perfectly, are there exceptions where breaking a safety law is legally excused?
Yes, the law recognizes that rigid adherence to a statute can sometimes be more dangerous than breaking it. The most common defense is a sudden emergency not of the defendant's own making.
Like what?
If a man is driving his wife, who is actively suffering life-threatening complications during labor, to the hospital, and he drives 20 miles over the speed limit to get there, he is technically violating a traffic safety statute.
Right.
But if he gets into a minor fender bender, the court will almost certainly excuse the statutory violation because the emergency justified the breach.
Okay, so let's check in on our hypothetical plaintiff. They survived the first two departments, they proved the defendant owed a duty, and they proved the defendant breached that duty, maybe using the hand formula, or a falling flour barrel, or a broken statute. Now, they must enter the most philosophically terrifying department in Negligence, Inc.
The SVP of Causation.
Causation.
This is where legal theory collides with the infinite complexity of the universe. It's not enough to prove the defendant was bad and the plaintiff is hurt. You must prove the defendant's specific bad act was the direct trigger for the plaintiff's specific injury.
And Negligence, Inc. splits this department into two distinct floors. The first floor is actual cause.
Actual cause is the raw physics of the situation. It's the factual, mechanical linkage between action and reaction. The standard tool for this is the but for test. We ask, but for the defendant's negligent conduct, would the plaintiff's injury have occurred?
If the answer is no, you have established actual cause. Like for you running the red light, my car wouldn't be totaled. It's simple.
Very simple. But the real world is rarely that clean. What happens when multiple things go wrong at the exact same time?
Right. Imagine two completely independent people accidentally start brush fires on opposite sides of a valley. The two fires rage out of control. They merge together in the middle of the valley into one massive inferno, and that inferno burns down a farmer's house.
If the farmer sues the person who started fire A and the court uses the strict posts, but for tests, the defendant will say, but for my fire, your house still would have burned down because fire B was coming anyway.
The person who started fire B will say the exact same thing about fire A.
Exactly. Under the but for test, neither of them is the actual cause, and the farmer gets nothing.
Which is an absurd result, so the courts invented a backup test.
The substantial factor test. When there are redundant or commingled causes, the court abandons but for and asks, was the defendant's negligent act a substantial factor in bringing about the harm?
So in the merged fire scenario, since both fires were capable of destroying the house on their own, both are considered substantial factors, and both defendants are held liable as actual causes.
Exactly.
There is an even more dramatic scenario called alternative liability, and it stems from a legendary California case called Summers v. Tice. I love this case because it reads like a logic puzzle.
It really does. It involves 3 men on a quail hunting trip. You have the plaintiff, Summers, and 2 defendants, Tice and Simonson. The 2 defendants negligently fire their shotguns in the direct line of sight of the plaintiff at the exact same fraction of a second.
Oh boy.
Yeah. A single piece of birdshot strikes Summers right in the eye, causing severe injury.
Summers sues both of them.
Wow.
But it's birdshot. It's impossible to run a ballistics test on a tiny little pellet to see which specific shotgun fired it.
Exactly.
So Summers cannot prove which hunter was the perception, but for cause of his blindness.
Under traditional rules, because he couldn't tip the scales of probability against either specific man, his case would fail. Both negligent hunters would walk away scot-free because the plaintiff lacked the impossible evidence.
But the California Supreme Court looked at this injustice and created alternative liability.
Right.
They basically shifted the entire burden of proof.
They told the 2 hunters, you both acted recklessly. You both fired in his direction. Therefore, the burden is on you to prove that your specific pellet didn't hit him.
Figure it out amongst yourselves.
Right. If neither of you can prove your innocence, you will both be held jointly liable.
It's an incredibly elegant solution to an evidentiary nightmare. Okay, so actual cause is just the mechanical physics. If you pass that, you take the elevator to the 2nd floor of causation. This is the domain of proximate cause, or as lawyers call it, legal cause.
If actual cause is the science of reality, proximate cause is the public policy of liability.
Think about it. If we trace cause and effect back far enough, we can connect anything. If I trace actual cause back far enough, I could technically blame Henry Ford for every drunk driving accident in history. But for him inventing the mass-produced automobile, the crash wouldn't have happened.
So the SVP of proximate cause exists to take a red marker, draw a line somewhere on that infinite causal continuum and say, liability stops here. And the determining factor for where that line gets drawn is almost always foreseeability.
Proximate cause asks, was the plaintiff's injury the natural foreseeable consequence of the defendant's specific negligence? Or did some extraordinary, freakish, intervening force enter the situation and snap the chain of liability?
We have 4 incredible cases that explore exactly where this line is drawn. We have to go through them because they read like movie scripts.
Let's start with a case from 1980 in New York. Dirty Aryan v. Felix Contracting Corp. Set the scene for us.
Okay, so Felix Contracting is installing an underground gas main on a busy street in Mount Vernon. They're legally required to set up a safe work zone. A traffic safety expert later testifies that to properly protect the workers from traffic, the contractor should have parked a heavy dump truck across the lane or built a massive dirt barrier.
But they don't do that.
No. Instead, the contractor merely places a single, flimsy wooden barricade in the road.
Okay, and working inside this poorly protected zone is the plaintiff, Harold Dirty Aryan. He is tasked with sealing the gas pipes. To do this, he sets up a massive kettle of liquid enamel, which is boiling at 400 degrees Fahrenheit right near the curb.
Meanwhile, a man named James Dickens is driving his car down that exact street. Dickens suffers from epilepsy, and tragically, he has failed to take his medication that day.
Oh no.
As he approaches the construction site, he suffers a massive grand mal seizure behind the wheel. He loses consciousness, his foot presses on the accelerator, and his car careens directly toward the work zone.
The car smashes right through that pathetic wooden barricade like a toothpick. It careens into the site, strikes Harold Dirty Aryan, launching him into the air, and simultaneously strikes the 400-degree kettle of boiling enamel.
It's horrific.
When Harold lands on the pavement, the boiling liquid splatters all over him. He erupts into a human fireball. Miraculously, he survives, though with catastrophic injuries.
So Harold sues the contractor, Felix, for failing to provide a safe work zone, and Felix's defense lawyers mount a classic proximate cause defense.
What do they argue?
They argue to the judge, yes, our barricade was flimsy, but we could never in a million years have foreseen that an epileptic driver would have a medical emergency at the exact microsecond he passed our site, lose consciousness, and cause a 400-degree fireball. That medical seizure is a freakish, superseding act of God that breaks the chain of causation.
It sounds like a really strong argument. An epileptic seizure causing a fireball is the definition of unforeseeable, but the court ruled against the contractor.
Right. Because the court made a profound distinction between the exact manner in which an accident happens and the general risk that the negligence created.
Okay.
The court explained that Felix Contracting did not need to foresee the specific medical history of James Dickens or the precise trajectory of a boiling kettle. What was highly foreseeable was the general risk that on a busy street, a vehicle might lose control due to a blown tire, a distracted driver, or a medical event and enter the work area.
Because the entire point of a heavy barricade is to stop out-of-control cars.
Exactly. Because the hazard that actually materialized, a car crashing into the site, was the exact hazard that made the contractor's flimsy barricade negligent in the first place. The seizure was not a superseding cause. Felix remained liable.
So if the risk you created is the risk that happens, you don't get to escape just because the exact details were weird. Let's look at the flip side, a case where the court decided the chain of causation was broken. This is Ventratelli v. Kinney, rent-a-car.
In this case, the plaintiff rents a car from the Kinney agency. The car has a severely defective trunk lid. It simply won't stay closed. It keeps flying open while driving.
And the rental company knows this.
The rental company is well aware of the defect, but they rent the car to him anyway. So the plaintiff is driving in the city. The trunk flies open again. He pulls over and parks the car in a legal, perfectly safe parking spot on Mott Street.
He walks around to the back of the car and stands behind it, trying to slam the defective trunk shut.
While he is standing there, focused on the trunk, a completely different driver named Maldonado is driving down Mott Street. Maldonado acts negligently, his car jumps forward, and he severely pins the plaintiff between the two vehicles, shattering the plaintiff's legs.
The injured man sues the rental car company. His argument is simple: actual cause. If you hadn't given me a car with a broken trunk, I wouldn't have been standing behind the car on Mott Street, and I wouldn't have been hit. I am honestly furious on behalf of this plaintiff because that logic is flawless. He was doing exactly what any reasonable person with a broken trunk would do. How could the court say the rental company wasn't liable?
It comes back to that red line of proximate cause. The court agreed that the rental company was the actual cause, the but-for cause, but they ruled that the broken trunk merely furnished the occasion for the accident.
Versus the occasion.
Yes. The court decided that while it is foreseeable a broken trunk might cause an accident while driving, like blocking the rearview mirror, it is not reasonably foreseeable that it would cause the plaintiff to be rammed by an independent, negligent driver while parked in a supposedly safe location.
So the other driver broke the chain.
Right. Maldonado's reckless driving was an independent, intervening act that entirely divorced the plaintiff's injury from the rental company's negligence.
You know, I am going to side with the dissenting judge in that case. The dissent argued fiercely that if you lease a car with a trunk that flies open, it is 100% foreseeable that the driver will have to repeatedly pull over to the side of the road to fix it, repeatedly exposing themselves to the inherent dangers of oncoming traffic.
It's a very compelling dissent, but the majority drew the line and the rental company walked away free. Proximate cause is always a battlefield of perspectives. Let's examine a case where the intervening act wasn't just negligent driving, but intentional crime. Metcalf v. Washington Heights.
Right, so the plaintiff, Michelle Metcalf, goes to visit her friend in an apartment building in Stamford, Connecticut. It's late at night, and the parking lot is dim. She goes to the front door and uses the electronic intercom system to call her friend's apartment. But the intercom buzzer is completely broken. Her friend can hear her, but can't buzz the door open remotely.
Because the system is broken, the friend tells Metcalf, "Wait there, I have to put my shoes on and walk all the way downstairs to let you in." While Metcalf is standing outside in the dark, waiting for the door to open, a man approaches her and brutally assaults her.
Awful. So Metcalf sues the property management company. Her argument is that their negligent failure to maintain a working security intercom forced her to remain stranded outside the building, which directly exposed her to the criminal assault. And incredibly, The trial jury agreed with her. They awarded her over $100,000.
But the appellate court stepped in and reversed the jury's decision, throwing the verdict out entirely.
Why?
Because of the doctrine of superseding criminal acts. The appellate court ruled that, as a matter of law, a malfunctioning intercom buzzer is not a security device designed to protect people standing outside a building. It is designed to protect the people inside.
Oh, I see.
The management company could not reasonably foresee that a broken buzzer would induce a random, violent street crime. Criminal acts are historically viewed as highly unpredictable, intentional forces that take complete control of the situation, superseding any prior passive negligence by a landlord.
So a third-party criminal act usually snaps the chain of causation. But what if the intervening act is intentional self-harm? This brings us to a deeply tragic case, Delaney v. Reynolds, which tracks how modern courts are rethinking foreseeability regarding mental health.
The defendant, Reynolds, is a police officer. He lives in a house with the plaintiff, Delaney. Reynolds is intimately aware of Delaney's fragile mental state. He knows she battles severe substance abuse, suffers from deep depression, and has previously articulated suicidal ideation.
Okay.
Despite possessing this critical knowledge, the police officer routinely leaves his loaded, unlocked service weapon in a duffel bag on the floor of their shared bedroom.
One night, they get into a terrible argument. Delaney storms upstairs. She grabs his loaded, unsecured gun from the bag. In a state of extreme distress, she points the gun at a window and pulls the trigger twice. For whatever reason, it doesn't fire.
Right.
Reynolds realizes what is happening and chases her upstairs. But before he can reach her, Delaney turns the gun on herself, places it under her chin, and pulls the trigger a third time. This time it fires, causing catastrophic injuries.
She miraculously survives, and she files a lawsuit against the police officer for his negligent storage of a deadly weapon.
How did the lower court react to this?
Yeah.
Because traditionally the law has a very strict view of suicide, doesn't it?
It does. The lower court immediately threw the case out on summary judgment. For centuries, the common law has viewed a purposeful act of suicide as the ultimate independent superseding cause.
Right.
The historical logic was that a person making the deliberate, intentional choice to end their own life severs all liability from anyone else. You cannot blame someone else for your own intentional self-destruction.
But Delaney appealed, and the higher court reversed it. They refused to throw the case out. How did they justify ignoring centuries of tradition?
The appellate court recognized a modern shift in how we understand mental illness and foreseeability. The court ruled that because the defendant specifically knew about her severe depression and suicidal tendencies, a jury must be allowed to decide if her tragic act of self-harm was actually a foreseeable consequence of his reckless decision to leave a loaded gun on the floor.
And there was another argument about her intent, right?
Yes. Delaney's lawyers argued that she didn't actually intend to die in that moment because the gun failed to fire the first 2 times. She believed it was unloaded when she put it to her chin, making it an act of extreme, desperate negligence on her part, but not a calculated suicide.
Wow. So the court concluded that when mental health and firearms mix, foreseeability is a complex question of fact for a jury to unravel, not a rigid mathematical line for a judge to draw.
Exactly. It's a harrowing example of how proximate cause is constantly evolving to match society's understanding of human behavior.
Okay, if our plaintiff has navigated the chaotic waters of duty, breach, actual cause, and proximate cause, they finally arrive at the final department, the SVP of damages.
This is the final stamp required to complete the prima facie case. Even if you prove the defendant was a reckless monster who broke every rule of cause and effect, if you don't have legally recognized damages, the SVP denies the claim.
There's a massive distinction in the law here that traps a lot of people. If someone commits an intentional tort against you, like battery or trespassing on your land, you can sue them and win, even if you weren't physically hurt. You get what are called nominal damages.
Yes, nominal damages might literally be an award of $1 single. It's a symbolic victory where the court says, you suffered a technical legal injury to your rights, and we acknowledge the defendant was wrong.
But negligence does not allow for symbolic victories, right?
No, negligence demands blood, or at least bent metal. If a drunk driver blows through a red light at 100 miles an hour and misses your car by a fraction of a millimeter, they clearly breached a duty and caused a terrifying event.
But if your car isn't scratched and you aren't physically harmed, you have no negligence claim. You cannot sue someone for almost killing you.
The system requires actual, quantifiable harm, medical bills, lost wages, property repair, or proven pain and suffering.
But what if you do suffer actual harm, and the injuries are exponentially worse than a reasonable person would expect? Let's say I'm at the grocery store. I'm distracted by my phone, and I negligently bump my shopping cart into another customer.
Okay.
For an average person, this would cause a tiny bruise. But the specific person I hit suffers from a rare, severe, brittle bone disease. The minor bump shatters their femur, requires 3 reconstructive surgeries, and leaves them with a limp for life. Can I argue to the SVP of damages that I shouldn't have to pay for 3 surgeries because a normal person wouldn't have been hurt that badly?
You cannot. This introduces the famous eggshell skull principle. The rule dictates that a defendant must take their plaintiff exactly as they find them.
So I have to pay for everything.
If you negligently injure someone, you are entirely on the hook for the full, catastrophic extent of their injuries, even if those injuries were magnified by a pre-existing vulnerability that was completely unforeseeable. The law says that between an innocent, fragile victim and a negligent defendant, the wrongdoer must bear the horrific financial cost of their bad luck.
I want to ask about emotional trauma because we said you can't sue for almost getting hit. But what if that near miss causes profound psychological damage? Can you sue for negligent infliction of emotional distress, or NIV?
You can, but the SVP of damages guards the gates of NE ferociously. Historically, courts were terrified that if they allowed lawsuits for purely emotional distress, the system would drown in a flood of fraudulent, frivolous claims over minor frights and bruised egos. How do you objectively prove someone is sad?
So what are the guardrails?
Generally, to succeed in an NED claim without suffering a direct physical impact, you must prove you are in the immediate zone of danger, meaning you are at genuine risk of physical death or injury. And most jurisdictions require you to prove that your emotional trauma resulted in verifiable physical manifestations.
So you can't just say, I have nightmares. You have to prove that the fright caused a heart attack or induced a miscarriage or caused your hair to fall out. The physical manifestation is the objective proof of the subjective trauma.
Exactly. It's the law's way of demanding an X-ray for a psychological wound.
All right, let's take a breath. Our plaintiff has done the impossible. They got approval from the SVPs of duty, breach, causation, and damages. They have built a flawless prima facie case of negligence. The Board of Negligence, Inc. has approved the project. Are they guaranteed a massive payout?
Not even close. Because getting approval from Negligence, Inc. just means you get to face the defendant in the arena. And the defense attorneys are waiting with an arsenal of weapons called affirmative defenses. These are legal doctrines designed to drastically reduce the payout or annihilate the plaintiff's case entirely by turning the spotlight back on the plaintiff's own behavior.
The oldest, most traditional, and arguably the most brutal weapon in that arsenal is contributory negligence.
For centuries, the common law adhered to a doctrine of pure contributory negligence. The rule was absolute. If the plaintiff's own carelessness contributed to their injury in any way whatsoever, they are completely barred from recovering a single penny from the defendant.
That means if a jury finds that the defendant was 99% at fault for a catastrophic accident, but the plaintiff was 1% at fault for tying their shoelaces too slowly, the plaintiff gets 0.
0. It is a draconian winner-take-all system. And we have a case that perfectly illustrates how ruthless this doctrine can be in practice. Massengale v. Pitts.
Let's hear it. Minda Massengale is driving her car through an intersection in Washington, D.C. The defendant, Martial Pitts, executes a reckless, negligent left turn directly into Massengale's path, causing a severe collision. During the trial, the judge explicitly rules that the defendant, Pitts, was guilty of negligence for pulling out into oncoming traffic.
But the defense lawyers start digging into Minda Massengale's behavior in the moments before the crash. They discover that her driver's license carries a strict restriction requiring her to wear corrective glasses while driving. She admits she wasn't wearing them.
Oh.
Furthermore, she testifies that as she was driving through the busy intersection, she was actively praying, suggesting her mind wasn't fully on the road. Finally, evidence shows that a taxicab driving directly next to her managed to swerve and avoid the collision, implying that if Massengale had been paying better attention, she could have avoided it too.
So you have a defendant who caused the crash and a plaintiff who was driving without glasses and praying. Under contributory negligence, what is the result?
The court rules that Massengale's failure to wear glasses and maintain proper lookout made her contributorily negligent. Because she contributed to her own demise, her case is thrown out. She receives absolutely nothing for her injuries and must pay her own medical bills.
It's staggering. But the courts eventually realized that barring a plaintiff completely for a 1% mistake was morally unpalatable. So they invented a loophole to save certain plaintiffs. We see this in the case of Dickerson v. Martin.
This case involves an 18-year-old high school student who is acting as a good Samaritan, crossing a busy street at night to fetch mail for a sick neighbor. However, he doesn't use a crosswalk. He jaywalks in the middle of the block. He looks once, sees the headlights of a car roughly 550 feet away, and then just starts walking across the street at a normal, casual pace without ever looking at the car again.
That is undeniably negligent pedestrian behavior. And sure enough, the car, driven by a 17-year-old who was speeding to pick up his date, slams into the pedestrian. The police find 140 feet of skid marks, proving the driver was going way too fast.
Under strict contributory negligence, this case should be over instantly. The pedestrian jaywalked and failed to maintain a lookout. He is at fault, so he gets nothing.
But the court applies the last clear chance doctrine. How does that work?
The last clear chance doctrine is a lifeline for negligent plaintiffs. It states that even if the plaintiff negligently placed themselves in a position of helpless peril, if the defendant had a final, clear window of opportunity to avoid the accident and failed to do so, the defense of contributory negligence is defeated.
In Dickerson, the street was well lit. The pedestrian was slowly walking across the road for up to 12 seconds before impact. The court ruled that a jury could easily find that the speeding teenage driver had the last clear chance to hit the brakes or swerve, but failed to do so because he was reckless.
Therefore, the pedestrian is allowed to sue, despite his jaywalking. It was a clever workaround, but ultimately the entire framework of contributory negligence felt inherently unjust.
Right. The idea that a plaintiff could be blinded by a drunk driver but receive zero compensation because they were driving 1 mile per hour over the speed limit offended modern sensibilities.
Which is why almost all jurisdictions in the United States abandoned it and adopted a much fairer mathematical system: comparative fault.
Comparative fault transforms the judge or jury into an accountant. Instead of an all-or-nothing battle, the court accepts that multiple people can make mistakes, and it assigns an exact percentage of blame to everyone involved.
Let's look at how this math works in the real world, using the case of Pohl v. County of Furness. Justin Pohl is a man visiting Nebraska on a hunting trip. He's driving down a snowy, rural gravel road late at night. He's driving 63 miles per hour. The speed limit is 50.
Up ahead, the gravel road takes a sharp, dangerous 90-degree curve. The County of Furness, which maintains the road, had installed a warning sign. However, at trial, a traffic safety expert testifies that the county sign was a disaster.
Right. It was heavily scratched. It completely lacked the legally required retroreflective paint, so it was invisible at night, and it was placed only 110 feet before the curve, whereas safety regulations demanded it be placed 300 feet back to give drivers time to react.
Pohl, speeding through the snow, never sees the invisible misplaced sign. He misses the curve entirely, flies off the road, hits an embankment, rolls his vehicle, and suffers catastrophic spinal injuries.
He sues the county for their negligent maintenance of the sign. The county immediately fires back with an affirmative defense. You were driving 13 miles over the speed limit on a snow-covered gravel road in the dark. You are at fault.
In the old days of contributory negligence, Pohl loses the second he admits he was speeding. But Nebraska is a comparative fault state. And what does the judge do?
The judge looks at the totality of the disaster and literally splits the blame. The judge determines that the county's failure to maintain a visible sign was the primary cause of the accident, assigning them 60% of the fault. But the judge also rules that Pohl's decision to speed on a snowy road contributed to his inability to control the car, assigning him 40% of the fault.
The court calculates Pohl's total damages, medical bills, pain and suffering, lost wages, at over $678,000. But he doesn't get a check for that amount, does he?
No. Because he was 40% to blame for his own ruined spine, the judge mathematically reduces his total payout by 40%. He walks away with roughly $407,000. Comparative fault ensures the plaintiff is punished for their mistakes without being completely destroyed by them.
Now, aside from proving the plaintiff was careless, the defense has another weapon: assumption of risk. This is the legal equivalent of saying you knew exactly what you were getting into.
Assumption of risk can be express or implied. Express is simple. You sign a liability waiver before jumping out of an airplane. You contractually agree not to sue if the parachute fails due to ordinary negligence.
And implied.
Implied assumption of risk happens when a plaintiff voluntarily encounters a known, obvious danger. If you choose to go to a baseball game and sit in the unscreened bleachers, you implicitly assume the risk of getting hit by a foul ball. You cannot sue the stadium if you get a black eye.
Okay, Contributory negligence, comparative fault, assumption of risk, these are all defenses that attack the plaintiff's behavior. But negligence, Inc., recognizes an entirely different category of defense that is infinitely more powerful: immunities.
And immunity is the ultimate trump card. It doesn't matter how perfect the plaintiff's case is, and it doesn't matter how reckless the defendant was. An immunity shields the defendant from liability simply because of who they are. It is a status-based exemption from the rules of civil justice.
Historically, these were massive, impenetrable walls. You had charitable immunity, where you couldn't sue a hospital or a church no matter how badly they botched a surgery or maintained their stairs, because society didn't want to bankrupt charities.
Right.
You had spousal immunity, where husbands and wives legally couldn't sue each other for torts.
Most jurisdictions have abolished charitable and spousal immunities, recognizing that accountability shouldn't vanish just because of a marriage license or a nonprofit tax status. However, some immunities remain fiercely protected by the courts. One of the most prominent is parent-child immunity.
This immunity prevents minor children from suing their parents for negligence. And we see how this operates in the case of Neal v. Ewell.
In Neal, a father and his minor child are cleaning up their yard. They are burning debris in a pile. Unbeknownst to them, an old pressurized aerosol can is hidden in the trash. The father leaves the child unattended near the fire. The heat causes the aerosol can to explode like a grenade, severely injuring the child.
The injured child, through a legal guardian, tries to sue the father, claiming the father breached his duty of care by failing to supervise the fire and failing to warn the child about the dangers of aerosols.
The court completely blocks the lawsuit, citing parent-child immunity. The court declared that it will not open the floodgates to lawsuits based on negligent parenting.
My initial reaction to this is absolute revulsion. Isn't parent-child immunity just a giant legal shield that gives bad, reckless parents a free pass to endanger their own children without consequence?
It absolutely looks like a free pass for bad parenting on the surface, but the policy rationale is actually designed to protect the family from outside predators. Courts are terrified of trying to establish an objective, reasonable, prudent parent standard because child rearing is heavily dictated by culture, religion, and socioeconomic status. Is it negligent to let a 9-year-old walk to school alone? A judge might think so, while a working-class parent might have no other choice. But the deeper, more cynical reason involves a procedural weapon called an impleader.
An impleader. That sounds like medieval torture. What is it?
It is a tactical legal maneuver. Impleader allows a defendant who is being sued to pull a completely new third party into the lawsuit and say, if I am forced to pay damages, this third party actually shares the blame and needs to reimburse me.
So how does that relate to a family?
Imagine a scenario where a mother and her 7-year-old child are walking down a sidewalk. A completely reckless drunk driver swerves onto the sidewalk and hits the child, causing horrific injuries. The family sues the drunk driver for millions of dollars.
The drunk driver is clearly 100% at fault.
You would think so. But if parent-child immunity didn't exist, the drunk driver's insurance company would immediately use an impleader to drag the mother into the lawsuit as a co-defendant. The insurance company would argue to the jury, yes, our driver was drunk, but the mother was negligent for letting her child walk 3 feet ahead of her. She failed in her duty of supervision.
Oh my God. They would blame the grieving mother to save their own money.
Exactly. They would shift a percentage of the comparative fault onto the mother. This would reduce the insurance company's payout, and it would effectively extract money directly from the victim's own household. Parent-child immunity acts as a force field. It legally prevents outside wrongdoers from using impleader to attack the family unit and victimize them a second time.
That entirely shifts how I view that rule. It's a pragmatic shield against corporate legal tactics.
Mm-hmm.
Now, there's one more massive immunity we have to discuss: governmental immunity. You cannot simply sue the state or the city just because you disagree with how they run things.
Sovereign immunity is ancient, stemming from the idea that the king can do no wrong. Today, it's about protecting the separation of powers. However, the government can't have total immunity, or municipal workers could run pedestrians over and street sweepers with impunity. So the law creates a razor-thin distinction between discretionary functions and ministerial functions.
The case of Peoples helps highlight this. Governments retain absolute immunity for discretionary functions. What does that mean?
Discretionary functions involve high-level policymaking, planning and the allocation of limited resources. It involves exercising judgment. For example, if a city council has a budget of $5 million and they choose to spend it on building a new library instead of upgrading a dangerous intersection with new traffic lights, you cannot sue the city when a crash happens at that dark intersection.
Right.
The decision of where to spend taxpayer money is a discretionary policy choice. If judges allowed juries to award damages for bad budgets, the courts would essentially be running the government.
But what if the city council does allocate the funds, they buy a brand new traffic light, and a city contractor negligently installs it upside down, causing a massive pileup?
In that case, you can absolutely sue the government. Because the physical installation of the traffic light is a ministerial function. It is the day-to-day operational execution of a policy that has already been decided. There is no high-level policy judgment involved in turning a wrench.
We see this exact breakdown in the Wisnet case. A worker at a naval base gets severely sick because he is exposed to toxic mold in the government facility. He sues the government for failing to maintain a safe environment.
The government's lawyers aggressively try to claim discretionary immunity. They argue that designing safety protocols and decide on how often to inspect for mold is a high-level policy decision.
And the court agreed with that part, right?
The court agreed that designing the policy is immune. But the court ruled that the actual physical implementation of that policy, the day-to-day task of inspecting the walls and cleaning up the mold, is purely ministerial. Therefore, the government is stripped of its immunity and must face liability for the workers' damaged lungs.
All right, we are nearing the end of this exhausting journey through the legal system.
Huh?
But there is one final chaotic twist. What happens in the aftermath when the jury comes back, but there isn't just one defendant? What if Negligence, Inc. finds 3 different people liable for the plaintiff's injuries? How does the bill get split?
This takes us into the treacherous realm of joint and several liability. Under traditional common law, when multiple tortfeasors, which is just the legal term for wrongdoers, contribute to a single indivisible injury, they are held jointly and severally liable.
What does that phrase actually mean for the plaintiff?
It is the ultimate plaintiff-friendly rule. Let's say a jury awards a plaintiff $100,000 and assigns fault to defendant A at 60%, defendant B at 30%, and defendant C at 10%.
Wow.
The phrase joint and several means the plaintiff does not have to spend years knocking on 3 different doors trying to collect $60,000 here and $10,000 there.
Oh.
The plaintiff is legally empowered to point their finger at any single defendant and demand the entire $100,000 all at once.
Wait, hold on. You're telling me the plaintiff can force defendant C, who was only 10% at fault, to pay 100% of the massive judgment?
Yes. The law prioritizes making the innocent injured plaintiff whole as quickly and efficiently as possible. It is not the plaintiff's problem to do the accounting.
But that is financially devastating to defendant C. Do they just lose all that money?
Not permanently, but it triggers a secondary legal war. Once defendant C pays the full $100,000 to the plaintiff, defendant C must now launch their own lawsuits against defendant A and defendant B to claw back their respective shares. This is known as the process of contribution and indemnification.
So the burden of collecting the money shifts from the innocent victim to the wrongdoers.
Exactly.
This dynamic must create an incredibly toxic, cutthroat environment among the defense lawyers before a trial even starts.
It creates a high-stakes game of legal chess because every defendant is terrified of being the one left holding the bag for the full amount, especially if the other defendants go bankrupt. This fear gave rise to strategic, often secretive settlements known as Mary Carter agreements.
A Mary Carter agreement sounds like a Cold War spy tactic.
It essentially is. In a Mary Carter agreement, one defendant secretly settles with the plaintiff before trial. They guarantee the plaintiff a certain amount of money, but in exchange, that settling defendant stays in the trial and actively helps the plaintiff shift all the blame onto the non-settling defendants.
That's wild.
The math of how this early settlement reduces the final jury award is dizzyingly complex, but the ultimate goal is always to maximize the plaintiff's recovery while allowing one defendant to legally stab the others in the back to save themselves.
It is a ruthless system. And that brings us to the end of our exploration. We've walked the intense, unforgiving halls of negligence. We saw how duty requires a legal obligation, heavily modifies for children and professionals, but ruthlessly protects the right to stand by and watch a stranger drown. We watched how breach calculates human safety through the cold algebra of the hand formula, relying on falling barrels and broken statutes to prove the unreasonableness of society.
We navigated the infinite complexities of causation, separating the mechanical physics of actual cause from the strict, foreseeability-based policy limits of proximate cause, grappling with epileptic drivers, defective trunks, and the tragic intersections of mental health and superseding acts.
We secured our physical harms with damages, forcing defendants to take their eggshell plaintiffs exactly as they find them. And we weathered the relentless storm of affirmative defenses, the brutal history of contributory negligence, the mathematical justice of comparative fault, and the invisible shields of family and governmental immunities. Every single one of these interlocking doctrines is necessary to form the foundation of civil liability.
It is a brilliant, deeply flawed, constantly evolving system. It is the only way a civilized society can balance the desperate need to compensate the injured against the absolute necessity of allowing human progress and industry to continue.
And as we leave this topic today, I want to plant a final provocative thought. We have spent this entire time analyzing human behavior, the reasonable, prudent person, but we are rapidly accelerating into an era of autonomous vehicles and AI-driven medical diagnoses. The landscape of cause and effect is shifting beneath our feet.
The traditional causal continuum is about to be shattered.
Exactly. Think about it. How will the reasonable, prudent person standard survive when the entity making the decision is a proprietary algorithm? When an AI medical assistant makes a diagnostic error that causes horrific harm, who assumes the duty, the software programmer who wrote the code 10 years ago, the hospital that purchased the license, or the machine learning model itself?
It's a legal nightmare.
And how in the world do we calculate the hand formula when the burden of fixing millions of lines of code is virtually invisible to a jury? But the probability of a microscopic digital glitch could instantly affect millions of patients globally. It's something to chew on the next time a piece of automated software quietly updates on your phone. We started this deep dive talking about the comforting clarity of an X-ray. Tort law has never had that clarity. It has always been the messy, emotional business of judging human behavior. But as machines begin to take the wheel, that diagnostic landscape isn't just murky anymore. It's written in code we barely understand, and the SVPs of negligence are going to have to learn a whole new language.